The title of my presentation is Intersection of Domestic and International Law, a case study of Malaysia's governance on COVID-19 pandemic. This is the outline of my presentation. Basically, there are 7 things to cover, including conclusion. Now, the objective of this presentation, there are twofold. Firstly, to examine the extent to which Malaysia's legal measures are implemented incongruent to prescribed international guidelines, and to analyse how the intersection of international law and domestic law convenes given the fact that Malaysia is a dualist state. We know that COVID-19 pandemic has its multifaceted challenges, and the challenges are both from domestic and international jurisdiction and legal system. The pervasive and transboundary nature of pandemic COVID-19 warrants the workings of international and domestic law to be intertwined, as a unilateral operation of either a legal system would lead to a futile and wasted effort. Malaysia as a dualist state. In managing domestic and international affairs, a state has to adopt and implement domestic and international law. And there are two ways to do so. A state can either become a monist state or a dualist state. A monist state belongs to those states adopting monism theoretical approach, whereby international law and domestic law are deemed as one unilateral legal system. And however, in the event where there is a conflict between the two, international law will prevail. Example of monist states are USA and France. For a dualist state, international and domestic law are deemed as two separate legal systems operating in its own sphere of legal influence. Thus, international law must be transformed to become domestic law for it to be applicable at domestic level. This dualist state also adopt what we call doctrine of transformation, and this is the practice of United Kingdom and most Commonwealth countries, including Malaysia. So Malaysia is a dualist state. This is Malaysia's legal framework for infectious diseases. We have enacted several pertinent acts when it comes to health issues. An example would be Private Hospital Acts, Care Centre Act, Medical Act, and the list goes on. However, the only statute ever passed on infectious diseases to date is the Prevention and Control of Infectious Diseases Act 1988, PCIDA. And as COVID-19 is the most recent pandemic, it is therefore not included in the list. However, the list in the first schedule of the Act is not rigid, and the spreading of the new diseases such as COVID-19 could be included in the category of any other life-threatening microbial infection. So, despite several episodes of past diseases outbreak, there is hardly any amendment to this Principal Act apart from the 2016 amendment. However, there is a saving provision that may have ameliorated the situation. The provision is Section 11.2 of Part 4 under the heading of Control or Spread of Infectious Diseases that give the Minister to undertake appropriate measures deemed necessary to curb change of infection. Reading together, Section 11.2 of Part 4 reading together with Section 31 of the same statute, the Minister is bestowed with the power to make wide range of regulation that are strategically capable to control further spreading of the disease. Now we are going to look at Malaysia and the National Legal Framework for Infectious Diseases. Malaysia has been a member state of WHO since 24th April 1958, and WHO Country's Office for Brunei, Malaysia and Singapore is located in Kuala Lumpur. We have been an active member of WHO and affiliated to the Western Pacific region. In managing COVID-19 pandemic at domestic level, Malaysia has been adopting and applying guidelines issued by the WHO. Over the years, WHO have repeatedly recognized Malaysia's technical leadership in areas such as health system, pharmaceutical, and tropical contagious diseases. Now, Malaysia Ministry of Health has set up international health units to implement the obligations stipulated in provision of WHO International Health Regulation 2005 or IHR. The Disease Control Division of the MOH, particularly the outbreak and disaster management sector, also play crucial roles in ensuring Malaysia's adherence to IHR 2005 relating to public health emergency of international concern or PHEIC. The IHR 2005 requires state parties to notify the WHO on the existence of any events that constitute public health emergency of international concern. Now, we're going to look at the intersection of international and domestic law in legal framework for infectious disease. What is IHR 2005? It's actually a source of international law because by definition, IHR 2005 is a legally binding international agreement between 195 countries or state parties. Article 2, Part 1 of IHR 2005 defines its purpose and scope as to prevent, protect against, control and provide a public health response to the international spread of a disease in ways that are commensurate with and restricted to public health risks and which avoid unnecessary interference with international traffic and trade. And it came into force on the 15th June 2007. The source of international law utilized by International Court of Justice are stipulated in Article 31 of Statute of International Court of Justice. According to definition of IHR 2005, it seems to fit the category enumerated in Article 38(1)(a), that is International Convention, whether general or particular, establishing rules expressly recognized by the contesting state. So we have looked at the definition of IHR and it fits this category of international convention under Statute of International Court of Justice. So what happened at domestic level when Malaysia takes action to implement the obligation under IHR 2005? We have come up with Malaysian Strategy for Emerging Diseases, MySET 1. We have come up with Malaysian Strategic Work Plan for Emerging Diseases, MySET 2, and Guideline for 2019 Novel Coronavirus Management. So, and we also have coordination between MOH and other government agencies such as National Disaster Management Agency, NEDMA, National Security Council, Ministry of Foreign Affairs, Royal Malaysian Police, Immigration Department, and etc. So, under International Legal Framework, we adopted the International Legal Health Regulation 2005, and under that, at domestic level, we have the Prevention and Control of Infectious Disease Act 1988. We have the National Security Council Act 2016, and we have MySET as well as MySET 1, MySET 2, and the guidelines in 2019, the guidelines 2019 coronavirus management. And these are the example that we have, the example of measures that we have taken under guidelines 2019 coronavirus management. All these we have gone through. And what are the dualist features in Malaysia government on pandemic 19? We have, based on the previous practice, we should have an enabling act. For instance, the Child Act 2001 was enacted to enable obligation under Convention of the Rights of Child Act 1995. And based on case law also, there are several cases that stated that we have to have enabling act in order for us to implement international law at domestic level. So, as a conclusion, there should be an enabling act to transform Malaysia's obligation under the IHR for it to become domestic law to be implemented at national level, or the Principal Act on Infectious Diseases PCID 1988 should be amended accordingly to implement obligation under IHR, even though Malaysia as dualist states has yet to take necessary action to transform IHR 2005 obligation. The MySET 2 has already identified and included in this crucial step in the strategic work plan for Focus Area 1. So Focus Area 1 is Public Health Emergencies Preparedness. One of the subjective activity is for the state parties to review existing all legislation, including any special measures needed for emergency response or recommended under IHR. The fact that there is a possibility of either an enabling act to be enacted or an amendment of PCIDA 2019 to be carried out suggests that In governing a pandemic, Malaysia is inclined to further enhance its dualist nature. So that's the presentation for today.